call this special meeting of the Dickinson County Board of Supervisors to order. I would note that all elected members are present, along with County Administrator Mr. Moore, County Attorney Mr. Phillips, Madam Clerk Mrs. Lyle. I'll go ahead and let Mr. Yates call his meeting to order if he would like to do so.
Thank you, Josh. I appreciate it. Yeah, we'll go ahead and call our meeting to order. Have all members present. I think Mr. Stanley's on the phone. Our executive director's in attendance. So our meeting's called to order.
Now, at this time, I guess we don't have an official agenda in front of us. My suggestion would be that we adopt the notice as the model form for our agenda. Is there any discussion or any other suggestions on that? If not, I would entertain a motion to proceed that way.
I'll make a motion to approve that.
So I have a motion that we use our notice as the model or as our agenda for the meeting. Do I hear a second?
I'll second it.
All those in favor of using the notice as our agenda, please signify by saying aye.
Aye.
Aye also. Mr. Yates, I'm not sure if you have any procedural matters as far as an agenda or anything you'd like to adopt.
We do have a need to adopt our agenda as presented here. Everybody have a copy of the agenda? Had a chance to look it over. Anybody need to make any changes or corrections to the agenda as presented? Okay.
I'll second.
All right, we have a motion and a second to adopt our agenda as presented. Any further discussion? Hearing none, all in favor?
Aye.
Anyone opposed? Motion carries. Thank you, Mr. Stanley. We do have an agenda.
Mr. Yates, I'm not sure. I believe you might have some more significant procedural matters as far as your electronic participation. I'll absolutely yield to your board to take care of those housekeeping matters if you'd like.
Right. Yes, sir, Josh. Thank you. How far down in our agenda did you want me to go?
Well, I guess if you want to take care of that first, and then I'll maybe facilitate after that, if that's okay with you. But I want to make sure we get that taken care of first.
All right.
If that's
Mr.
okay.
Chairman, if I might, we're helping the IGA tonight with a couple of procedural matters.
Okay.
And one of those matters is a adoption of a policy regarding electronic participation in meetings from remote locations. From other meetings that I've been to, the chairman and members thought that they had adopted this policy, and there's been reference in your bylaws that you have an electronic policy. And something was in the minutes saying that you're going to allow, you would allow matters regarding remote meetings policy, that you were going to adopt a policy or did adopt a policy, but it wasn't clear from the minutes. And as abundance of caution, Mr. Stanley would like to participate potentially by remote access, but out of an abundance of cautions, I felt it's very important that you might want to consider readopting or adopting the policy regarding electronic participation in meetings from remote locations. And so that may be the first thing that y'all consider.
Okay, well, thank you. And I appreciate your explaining that to me. I had the same questions. I wasn't sure that we'd ever adopted the policy, but I have read the policy that was sent to me last Friday, and I think we do. Yes, I'm gonna get to that in just a second. But we will be in compliance. Mr. Stanley had notified me earlier today that he was going to attend by electronic telecommunications. So we'll get to that in just a second. Let's go ahead and observe a moment of silence as an item on our agenda right now. Thank you all. Okay, and once again, thank you. Next item on our agenda is item number 4, the conflict of interest for anything that's on our agenda for today's meeting. I have none.
I have none.
John? No conflict of interest. Okay, item number 5 then would be to adopt a policy regarding electronic participation in meetings from remote locations. Everybody should have a copy of the policy that we're going to adopt here. I hope you've had a chance to look at that over.
As far as I can tell, it's an extension of the policy we thought we had adopted.
I believe it is too.
Yeah. It would be identical, I think, to that. We think that it is.
Looks like it fits their needs very well. So I'll open the floor up for motions on that policy, adopting that
Chair,
policy.
I'll make a motion then that we adopt the policy for participation in electronic meetings.
Okay. Motion and a second. Thank you, gentlemen. Any further discussion? Hearing none, all in favor?
Aye.
Anyone opposed? Motion carries. Item number 6 on our agenda then would be allowing, a vote allowing Mr. Stanley, Donnie Stanley, a member of the Industrial Development Authority.
Mr. Chairman, I move that we allow our board member, Donnie Stanley, to participate remotely.
Okay? Motion and a second. Any further discussion? Hearing none, all in favor?
Aye.
Anyone opposed? Welcome, Mr. Stanley.
Mr. Chairman, if I might, to make sure we're in compliance with the law, there's 6 things that we have to find or touch before
Yes.
we can actually allow Mr. Stanley to participate.
Mm-hmm.
The first thing is the chairman has to, for the record, note that there is a quorum that is assembled here tonight on your meeting. And so if you can make that notation of a quorum, please.
Yes, sir. I will note that the Industrial Development Authority does have a quorum tonight.
The second matter that must be satisfied, the remote member's voice must be heard by all. And so, Mr. Stanley, could you speak up and make sure everybody can hear your voice?
Yes, I'm speaking now.
Okay, so if the minutes could reflect that, assuming any one of the members of the IDA was not able to hear his voice, was everyone able to hear Mr. Stanley's voice? The third thing that must be satisfied, Mr. Stanley must notify the chair of his inability to be here and the medical condition that does not allow him to be here. Has he satisfied that, has he provided you with this notice?
He provided me with a notice, Mr. Phillips. I'll have to take one more look at it here to make sure.
And so we probably need to read that in the record if we can, his notice to you. And yet,
Okay, you ready for me to read this? into the
please,
record?
Mr. Chairman.
Chairman Yates, please allow me to participate in a special called joint meeting this afternoon, Monday, August the 31st, 2020, at 5 p.m. I am currently quarantined due to COVID-19. If you have any questions, please feel free to contact me. Thank you, Donnie Stanley.
Thank you, Mr.
And that
Chairman.
was at 1:46 p.m. today.
Okay, the fifth thing is that the minutes must record the location that Mr. Stanley is participating from. Mr. Stanley, could you tell us exactly where you are?
I'm in 201 John Dane Lane,
Is that
Glenwood, Virginia.
Clinton, Virginia? That's where you're calling from today?
Yes,
Okay. And there was a vote, has to be a majority of the vote. Was there a vote of the IDA authority with the majority allowing Mr. Stanley to participate? I believe it was unanimous, I think. Okay. And based on that, it's my opinion that all of the conditions and criteria of your policy and the statute dealing with remote participation by someone who has been quarantined as a result of coronavirus can now participate by electronic means, and he also has a voting privilege as a result of that. And so any questions by any members about the procedures or process that you've gone through? Okay, thank you. Now, Mr. Stanley, you have satisfied all of the requirements of the statute and the policy that they just adopted to allow remote participation due to a medical problem or causation. You can make motions, you can discuss any issues, and certainly you have a right to cast your vote as you see fit on any matters that come before the IDA today. Do you have any questions, Mr. Stanley?
no, I'm fine, thank you.
Thank you, Mr. Stanley. Mr. Chairman.
Thank you, Mr. Phillips. Josh, do you need to jump back on your part of the agenda, or?
Well, Mr. Yates, I don't have your agenda, so I don't know if there's any other procedural matters you have before
Well,
you.
our only remaining business is the school litigation.
Yes, sir.
Division of money accounts and members' comments and adjournment.
Yeah, I'll jump back in if it's okay with you. As everyone knows here, I guess by now, my board, our board, the Dickinson County Board of Supervisors, and also now, as we speak, the Dickinson County School Board has now approved. Our board was a unanimous vote, 5-0. I believe the Dickinson County School Board vote was a 4-1 vote. So now 9 out of 10 elected legislative members, I guess for lack of a better term, have voted to approve this joint resolution that your board now has in front of you. And it's been an extremely long, hard, rocky road to get to this meeting that we have here tonight. Looking back all the way to January, I did today, and I printed off every email, every correspondence, every proposed resolution. Didn't bring them all, but I printed off literally every sheet of paper that had been passed between the two boards, the Board of Supervisors and the school board and our lawyers. And it was literally a stack this high of correspondences and things that have gone back and forth. And there's never a winner typically when you litigate. Even the winner sometimes doesn't win. And in this case, I'm not sure either board or either end of the county or however you want to say it is necessarily a winner. The way our board has approached it is to try to be responsible stewards, number one, of the taxpayer dollar, which is our primary responsibility, is managing the budget for Dickinson County. And number two, trying to do what we feel has been in the best interest of the children and families and working people of Dickinson County. And with the assistance of our legal counsel, who we have exceptionally knowledgeable and done a wonderful job of advocating for our interests and the county's interests, have put forth this resolution that we believe will end what has been an absolute and utter nightmare for the citizens of Dickinson County and the board members, past and present, who have dealt with this issue. I look back at the court file today as I was going through all this. The complaint by the Dickinson County School Board was filed June the 19th, 2019. So I hope y'all let that sink in a moment. Here we are, August 31st, 2020. That's embarrassing to me. And I've been on this board since January 1st of 2020, and it's August 31st, 2020. So that alone is embarrassing, not even counting the 6 months or so before I even took this office. But as you can see, this joint resolution, Mr. Yates, that your members have before you is extremely simple. It's a 3-page document. It's actually 4 pages, but the last page is signatures only. This board has gone above and beyond in trying to be reasonable. As you'll notice from page 4, there's a $600,000 202 credit that has absolutely and literally nothing to do with the school board litigation or the site of an elementary school. But that has come in to this conversation for frankly reasons unbeknownst to me. I mean, I understand the reasons, but it's really not a part of where an elementary school's built. But that's how far this board, my board, has come in trying to get this animal resolved. And during the 8 or 9 months we've been doing this, it's been things like that that have come up time and time again. And the reality of the case is, when we took office, when this board, and there's 2 members that have been here, Ms. Willis has been here a long time, and Ron was here a term before myself and Ms. Sluss and Ms. Kaiser. Our council have basically said that, in their opinion and their research of the law and the Constitution of Virginia, that site location is ultimately going to be decided by the school board. No matter what we do, no matter how much we fist fight each other, no matter how much money we spend, it's over $250,000 at this county. Now, that's not the Virginia General Assembly appropriating $250,000 to us. That's not the United States Congress appropriating $250,000 to us. That is Dickinson County money, my money, your money, John's money he tries to earn every day. Everybody at this table's family's money that's going to fight each other. $250,000. What could be done for $250,000 for this county that we've spent tearing each other apart. And so realizing the realities of the law, realizing how long this thing has been pending, June, it's been even pending longer than that. Mr. Willis's and Mr. Peters' board, 2 or 3 years even before they instituted the litigation. The litigation was instituted June of 2019, and here we are, August of 2020. So that's where we are, and I don't want to belabor it and be long-winded. It's been a long road that we have hoed. And of course, Shelby, she's had a very long road that she's hoed
dealt
with it.
from the very beginning.
But this board is committed to looking out for the taxpayer dollar. And number 2, looking out for the families, children, and working people of the county. And we have pounded out this resolution with the assistance of our counsel, who's been wonderful. And I hope and encourage you to adopt this resolution in this litigation and allow the IDA and the Board of Supervisors to get back to the business for which the General Assembly says that we're supposed to do business. We're supposed to manage the local budget. You're supposed to recruit industry and development. My board, I'm not in the business of building schools and choosing school sites. And with all due respect to you all, you're not definitely in that business. The Industrial Development Authority is in the business of industrial development. And I understand in the beginning when Ridgeview was being built that, and you know, the Industrial Development Authority played a critical role in the incremental financing and the ability to raise funds, adopt funds, borrow funds to get that project on its legs. But at the end of the day, that's really what the purpose of the IDA was. It wasn't to govern. The elected people are elected to govern. And don't mean that in any sort of derogatory way. I don't mean that in any way other than just that's the reality of the law, reality of the Constitution, and the reality of America. Elected people govern. That's what we were elected to do, and it's been extremely difficult, and I don't want to sit here. I'd assume not be making this decision, just to be honest with you, but we have made it, and I feel like I've been in a boxing ring with Mike Tyson for 8 months. I mean, I don't feel good about this necessarily, but we've come out of the ring trying to end the fight and trying to move Dickinson County forward. And so I hope that you'll adopt the resolution, and I hope that you will, if you disagree with anything that I've said, you can somewhat empathize with my position, our position. If you can give us that much as empathy, as fellow citizens elected to do a very difficult job, and this was an extremely difficult job that we have bonded together, frankly, over and struggled with, labored over. But this is where we are, and we feel like this is the right thing. And it was a unanimous vote. And I'll now allow any other members of on my board, I've spoke, but if there's anything that anybody else wants to say on my board, please take the floor to do so. Mr. Phillips, is there anything else that you would add to my remarks?
No, Mr. Chairman, you did an excellent job of summarizing where we've been over the last probably, going on now, at least 3-4 years, almost 3.5 years, I guess, in terms of moving the school ahead. The school had been stalled out probably at least 2 years, almost 2 years before this lawsuit was filed, so it's been at least 3 years. But I thought you did an excellent job of summarizing where you've been and where we are, and I wouldn't have anything to add. You've touched on each issue that I would have touched on.
Mr. Gates, we've sort of ended, I guess, number 1 on our agenda. I would now,
Okay.
go ahead, yes, sir.
I'm sorry, I didn't.
No, please, go ahead.
Look, I'm not happy with this. But it is what it is because it's like going to a gunfight with a knife. In January, when our legal team talked to us, that was the change. We don't have any legal authority that can compel the school board. The only chance we had was if we'd had enough members on that board in favor of that. And so that's, do I think this is the best ultimate decision for our community and children? No. But I think it would be worse to continue the fight and let the money just dwindle away to where we can't build anything. So I'm ready to press forward.
Anyone else?
In my area with campaigning out last year, campaigning in the Irvington district, borders right down towards Sand Lake. Kids in my district goes to Sand Lake. I would like to had seen the school board made a choice to honor why they was building the school is because of Sand Lake flooding. But my biggest questions when I was campaigning was, and I'm not going to call the name or what department or what, but people wanted to know when was the Board of Supervisors going to get rid of some people. And I said, if they're not directly employed by the board, we can't. People wanted to know when was the younger kids going to be able to benefit from a new school like the high school and middle school was. And people who I talked to, they was teachers, they was citizens, parents with kids said, make a decision, we'll live with it, but stop the money spending, is what I heard when I was out campaigning. So it's hard decisions. It would have been a good thing if previous boards could have ended this before 3 new ones come on here, 3 new ones come onto the school board. We got a couple of new ones out here, 2 or 3 new ones. But I think our county is ready for decisions and movement. Too many people in this county needs internet and needs other services that the IDA to bring in somebody in here that can get this industry going, because no time did we realize when March hit and COVID come that 5 months later internet was going to be a demand, and it is a demand right now for education for children.
Well said, thank you. Anybody else? I'll turn it over to you, Mr. Gates, at this point.
Thank you, Chairman Evans. I'm not here tonight to debate the law with anybody. I'm not a lawyer by trade. All I can do is just read, try to understand the law, and I do a lot of that. I have some questions that I'd like answered here tonight, and I want to pose them to Chairman, to other members of the board, and to Mr. Phillips over there. But if any of my board members would like to go first, I welcome you to do that.
Well, I just had one thought, and I do agree with Mr. Evans and Mr. Peters. This is something that I feel has needed to end for a long time, and I don't agree with the direction the school board is going as a citizen. As I know a lot of you probably feel the same, but I do agree we need to stop spending money needlessly, and this litigation was needless, and we need to move forward. I would just like to see us get a school built that our elementary kids can have, the same opportunities those kids up at Ridgeview have, and I want to, I would love to see us have, see them have enough money to be able to build a bigger school than what, I hear is being proposed. And if there was some way that our county could help out, I would be all in favor of doing whatever we could to get them a bigger school, a bigger building that would accommodate the entire county, all the kids, without having to shuffle around anything, because I don't know exactly what their plan is, but I can speculate, as anyone else can. But I do agree that it is time for the litigation and the wastefulness and all those things to end.
Anyone else, John?
I
Okay.
do have something I want to say, but you go ahead.
Made a mess,
Paper
as
towels.
usual. Clumsy. I think my grandson's clumsy.
Does that include Bud's fees.
Thank you,
I
Matt,
know, but it
for your,
would be in plus that. Yeah,
you know, as recent as July the 28th, I was told that,
Because indirectly we pay that.
this facilities development agreement had no weight. That, that was all settled in the past, that it was an illegal document to begin with. You know, I don't see how we can get up to this point with a contract that's worked so well for us and then throw it out the door. We're here tonight because the facilities development agreement is doing what it was designed to do, to bring about these discussions and trying to keep any one particular one of these three boards from taking control of this process. So that's why we're here tonight, because of the facilities development agreement. And it's doing what it's supposed to do, causing a good, strong discussion. But when you have a contract with someone, and I've entered into many, many contracts in my professional life, you don't do half the contract and then throw it out because you don't like the rest of it. You know, the town of Hayside went into multiple contracts with state agencies and government agencies. Appalachian Regional Commission, Virginia Department of Conservation and Recreation, Virginia Department of Housing and Community Development. If we go into those contracts and come out of it like we are here today, saying, you know, the contract's not working anymore, let's just throw it out. Do you know what their reaction to that would be to the town of Hayside? We would never be the recipient of another grant dollar. We would also have findings on our audits. Folks, this is Dixon County. We don't lie to each other. We don't treat each other this way. We don't go back on our word. It's like we're settling for second best. I'm sorry, that's just the way I feel. I think the school board signed away their right to choose the location of the school whenever they entered into the agreement with the facilities development agreement. I think the resolution is non-binding. I think two prior school boards voted to build a school at Hayside. Have they ever rescinded those votes? This resolution here combines not only, there's a lot of good could come out of this resolution. I don't see why you find it necessary to bring it to 600,000. Let's put aside for the Hayside Town Hall. Whenever the Hayside Town Hall suffered the same fate as the Sand Lake Elementary School, we were flooded. We deserve to have a safe building for our town and its citizens. In the end, this should never cost the county anything. This is core money. But there are a lot of good things in this resolution. The QSCAP funds should have been invested several years ago. You know, do y'all realize how much money we've lost? And who's the fault of that? It's not anybody in this room, I don't think. I'm not pointing the finger at anybody in this room.
I know how much we've lost. We've lost millions.
Hundreds
We've
of
lost
thousands.
probably $1 million, Ms. Willis.
Yes, we have.
We're in excess. That would have really been good to have that today, or in the future. But I just, you know, I would love to be able to vote for this resolution. I would love to be able to vote for the
We voted numerous
investment of the
times for
QSCAP
that,
funds.
didn't get it.
I still think we're settling for second best. And I don't know, you know, I understand the responsibility of the Industrial Development Authority. I know that we're tasked to do what you all ask us to do. But if you look at the code section, 15.2, 4900, there's a lot of things in there that an Industrial Development Authority does have the authority to do. And build schools and operate, or own schools and operate was one of them. So, you know, like I said, I'm not here to debate with anybody over the law. That's not my job. I'm just here to try to convince people of right and wrong. I'm gonna vote with my heart tonight, and I hope you all don't hold it against me. Shelby, you or Shane, either one? Excuse me, Ginger?
You need to recognize Mr. Stanley also.
Mr. Stanley,
Yes,
can you hear us okay?
yeah, I can hear you.
Do you have anything you'd like to add to the comments that's already been made?
No, I'm fine.
Okay, thank you, Mr. Stanley.
Larry, I do have a question.
Go ahead.
You know, I think we've all struggled with this. that's elected by the public. And I think we need to look to the people that appoint us. They're the ones who really have to have to put their neck out on the line. And of course, I've talked to my board member, Shelby Willis, who's always has wise counsel. I appreciate her. I don't think the IDA ever should have been in this process to begin with. The facilities development, I don't speak to the legal issue, but I think it was probably just a way of showing some unity and that kind of thing, but of course we came down to this. So anyway, it is a really difficult process, and no matter how we do it, somebody's going to be disappointed and going to be hurt. I was encouraged by what Mr. Peters said. I know he's struggled with this for a long time, and I believe he's come to the understanding that of the legal issue and that there was no standing. And so I think it's time that we get on with this. And, Mr. Chairman, I'm prepared to make a motion to accept this resolution.
I think Mr. Johnson had a question.
Yeah, John, I believe did have a question.
Just had a curious question, Mr. Evans. So I think I heard you say that it was a unanimous vote by the Board of Supervisors after much discussion. I understand that. And the school board, there was only one in opposition. So that was it a total of 19 people?
9 people.
9 people.
Correct.
9 out of 10 people.
Correct.
Altogether. So 2 boards have passed the resolution.
Correct.
2 elective boards.
With
Two elected
90%
Yes.
approval.
So what relevance, I mean, other than just, I guess, what does our decision weigh in on that?
Well, I'm going to answer what I think, and then I'll let Mr. Phillips clarify if I miss it. But the IDA is a party to the Facilities Development Agreement that Mr. Yates was discussing. And the reason they was primarily, if not only, for the ability to pass through monies that this board could not otherwise borrow, the rural development monies, the QSCAB. Well, we actually done the QSCAB, I think, but the 42 million rural development the IDA was a part of that borrowing process that we wouldn't otherwise have been able to borrow. And so therefore they had to be on the Facilities Development Agreement, which is in litigation in the Circuit Court of Dickinson County right now. So really in regard to the elementary school, we've agreed to finance incrementally up to $1.5 million, well, $1,580,000. We essentially don't need the IDA.
Mr. Evans, may I speak to that for a moment?
Right, if you want to correct me if I'm wrong, but moving forward, we don't need any.
It's not a correction, but maybe just a perception. The IDA would have always stood ready to do the interim financing and the bidding and, Mr. Phillips has explained to me, the purpose that the state legislature even started the IDAs. And so we would have always stood ready to do that without the Facilities Development Agreement. And that, I think, truly, the Facilities Development Agreement came around because we thought that showing unity would be a real encouragement for the Corps. I don't believe that the IDA ever had to be in it. I've asked a number of times if the Corps had required that, and I've always been answered that there was no requirement.
Yeah, well, I don't think they were required to, but just to answer Mr. Johnson's question, the IDA borrowed 7.5 from Wells Fargo.
Exactly.
And 42.5 from rural development.
And we would have done that in any case.
Right, either way, right, I
Yeah,
understand.
that's my point. The IDA always stands ready to do that, and we still will do I know you all are prepared to do the interim financing, but the IDA is always prepared to do its job.
Mr. Phillips, was I correct in that?
Mr. Chairman, your analysis is correct. Mr. Johnson, and I think Mr. Johnson's question is, why does it require your action tonight? I think that's...
My curiosity was if both boards have approved the resolution, what implication, if this board does or does not, does it really matter? I mean,
That's a good question.
It does matter, and let me tell you why it does matter. You all are defendants in the lawsuit along with Dickinson County. And the way that this works, in order to resolve the litigation, you have to also approve this tonight, this resolution.
And that's a step to resolving the litigation.
This way is the last step.
Okay.
All other
The
matters,
step.
all other matters, the tough issues have been resolved. The only other issue remaining is the division of certain monies, and you're on the account. You're actually listed on the account, and so you have to vote to release those monies to each of the parties. That's part of this tonight. And the Board of Supervisors is due to get $6.9 million, the QSCAB money, which they're going to invest in, or in some form. And the school board gets about 860 or 70, whatever the resolution says, $70,000 that they'll be using for the school. Without this resolution, the school board won't have the roughly, let me make sure I get that correct. The amount is, let's see,
804,795. Is that the number you're?
let's see what
What's
the
the
number is.
difference between 6.9 and 6?
Is $804,000, $795 that they need to move forward with the school. So this is actually in their plan of construction to use this to help finance the school. That's why this matters. It does matter. It's a very important resolution. And it resolves all the litigation issues. Two, it puts roughly $6.9 million back to the county and gives the school board $804,000 to put on the school.
We move on from this.
You do.
I think the public also needs to know that the 6.9 has to be paid back.
Yes.
It's not something that
No.
the county's getting, and we're gonna have,
It's an,
$6.9 million to spend, but, Mr. Phillips, but we do intend to invest it when it has not been, and get a little bit of interest back on it until we have to pay it back, because you are, if I understand, Mr. Phillips, you are, if you pay it back, you don't pay it back at certain times, you can be, have to, you tell that,
You can't pay it by lump sum
Yeah.
without paying a penalty.
yes.
right,
It's a
without
bond
penalty,
debt.
right.
And you
Yeah,
don't know if you
QSCAB
trade in
bonds.
bonds, but there's always a penalty.
If you pay it back.
And the Board of Supervisors incurred $10 million in bond debt to facilitate and pay for some of the incremental financing at Ridgeview. So that's money that we've done borrowed, and I mean, that's
We have
been.
to pay it back.
Exactly. Mr. Philip, Mike can articulate it better, but
Well,
yes.
Ms.
Phillips.
Sluss and Mr. Chairman are correct, Mr. Johnson, is that it was a bond that they borrowed to finance the high school. And the way this bond is set up, there is a major prepayment penalty. If you pay, that sounds silly to a lot of folks, but anybody who borrows money, in some cases, or bonds, these bonds got to mature. And if you prepay it, you're going to have to pay a major penalty to prepay it. And so the funds, the $6.9 million, is dedicated toward the reduction of those bonds without a penalty. And so those monies are not to be used for any other purpose other than repayment of those, and that's what they're dedicated for.
I appreciate you both answering my question. Thank you.
Mr. Phillips, may I ask a question?
You may,
You know, one of the issues initially was that we wanted to be absolutely certain that the QSCAB money that had been reserved would be sacrosanct, would never be used by, for any other purpose.
But for the debt, right?
But for the debt, that's correct. And, these good folks aside, are there any protective measures down the road that will assure that QSCAB money, once in the hands of the Board of Supervisors, will not be spent, it cannot be spent by future boards?
Mr. County Administrator, I might defer.
Yes, our intent is to look at, I believe you had a structure discussed with you years ago.
That's
And we actually thought we were going to get to invest it.
Right.
What we'd like to do is lock it away in a mix of short, medium, and long-term investments, because the entirety of the bond doesn't mature until 2032.
I know.
So, over that course of time, what we intend to do is set it up, locked away in its own mechanism. Also, we were told at that time that instrument could be used to pay the payments.
Right.
So, yes, our intent is to lock that money away in that same
But that's my concern, Mr. Moore, is that, you know, not these people, because they understand that they have that debt. But down the road,
That is 100% our goal to make it as airtight.
you think you can achieve that? But it is,
I don't know that anything can be 100% said,
I understand.
because
Well, it can't be, but
future boards can basically do their own, but we can do everything we can now to make sure that happens.
Well, if we inform the citizens, maybe they can control that with their vote as well.
People that want to filter away the money that's in the
Let's
bond
go.
payment.
Oh,
go.
Thank you.
I think
Mr.
that,
Mr. Peters has a question.
Okay, I'm sorry.
Go ahead, Ron.
Well, I got a couple other, you know, I want to be clear here. I looked at the contract the same way. That's how we looked at it the last 4 years. It was in January when you weren't on board yet, Phil, when our attorney up in Roanoke explained. And I remember reading the court documents, and the main emphasis in those court documents was the Board of Supervisors' control on this whole thing had to do with maintaining the purse string, not telling where the school is built. And that was an eye-opener, because it went right with what I was trying to do the whole 4 years, is get control of the finances, and we couldn't get there. But that said, I wanted to clarify something, and I'm not wanting you to think I'm picking on you, Larry. I appreciate what you said. But I wanted the 600, you opened up a question for me, and I was gonna use Bud to kind of answer. I don't agree that it was mentioned in here, the 600,000, but I knew it was gonna be. So I'm not trying to say that's a surprise. But I don't think that's money being taken away from Hayside.
No.
That's money, if that was money we put there to match.
No, I know it's not
And
money.
now they're saying, I just wanted to clarify that for myself.
I'm
not
glad
saying
you did.
I understand this.
Because your town hall's gonna get moved either way. That's the
Yeah.
point of why this.
No, and I want to imply you did, Larry. I want to make sure that that's clear, because I thought I heard it wrong.
Well,
and
you know,
I-
I've heard the remarks that's taking 600,000 away from the school construction budget,
Right.
But that's not
That's not
accurate.
so.
and I don't think that's true.
No, it's absolutely not.
No, we know that
We have
did-
said, if we did not need that 600,000, we'll go back, we will give it back to the school.
Now, we know we did a lot of in-kind work and all that too, so that's watered under the bridge at this point. We've got to move forward, is all.
I
Thank
think
you.
we have a motion on the floor.
Mr. Chairman, I would like to just take 1 second and further clarify my motion. Make it with any kind of joy or anything, but in order to make our county move forward, we've got to get our children taken care of. And as Mr. Peters has pointed out, we can sit here until the money moss is over, and it will not change the fact that the school board has the right to make that decision. And if that's what we're fighting over, that's why I move to approve this resolution, if that's what it takes to get us to moving forward. That's why I make that motion.
You need to say anything else?
What has the school board given up if this resolution passes? For what they originally wanted, if we pass this resolution tonight, what have they given up?
Mr. Chairman, may I answer that?
Please.
They have agreed to have in place various procedures and restrictions not to allow them to exceed their budgets, to go over their budgets or make any change orders without the approval of this board. In addition, they have given up a claim to $6.9 million. Now, you have to understand, that was generated to the core. And there was this gentleman's agreement in a sense, and there's some things in the document about the $6.9 million. They could have still litigated that issue and tried to make a claim against the $6.9 million, which would have bankrupted this county in a sense.
Because that's in an account in their name only right now.
It's in an account and with 3 names on it, actually. And it's got the school board, the IDA, and the Board of Supervisors, and that's why it needs to be segregated and apart. Now, the other issue that we've got in this agreement is something that's not a part of your agreement tonight, is an assignment. The school board agreed to assign their account at the core to us in case they didn't make the payments back to this. So there's substantial things that they have done. Those are probably some of the major things that they've agreed to. And so one of the things that this board, when I say this board, was concerned about is to make sure that there was no runaway school board, no runaway construction account, and which would cause this board to either raise taxes or to come up with funds somewhere to pull the school board out of the ditch if they got in problems with an overzealous construction project. And so this board consistently told me, my direction was to make sure that we get in these documents, agreements, that this board will have control over any of the change orders, any of the proposed changes that goes into the agreement, and to make sure that this board is notified of issues or problems up there that may occur. So those are some of the major issues that we got out of this. Now, you could argue, well, the issue here, and I want to be very clear, and sometimes it's hard to artfully state what needs to be said, but I'll do my best to do that. When this agreement was put together between the three, Ms. Senator is absolutely correct. One of the reasons why the IDA was put into this, because there was a feeling that it would make this whole project very unique, and that it looked like all folks were playing together, and everybody's cooperating together, and all three parties would move together jointly. The Board of Supervisors and the IDA did not give up anything in that proposed agreement that was reached. That was called the Facilities Development Agreement. It was the school board that allegedly wanted to give up the issue of construction, joint construction, and the other issue is joint decisions where the school would go, a location. Well, that facilities agreement worked well until it didn't work. There came a point that it didn't work, period. And that's when it all broke down over almost 3 years ago. There was a discussion, and I'll be frank with you, and I've been frank with some of you, there was a decision to take the school from one location and potentially take it to another location. And that was the issue of going to Hayside versus some other location, particularly Ridgeview. When that all happened, that's when all this fell apart. And that's when the school board basically filed a lawsuit and said, court, we said in our facilities agreement that the school board was going to give up a legal right to decide where that school goes. That's called a statutory right to build that school. In all the code that you go to, it doesn't say the IDA has the authority to build a school and to select a site. It doesn't say the Board of Supervisors. It says only the school board, by statute and by the constitutional basis of that statute, says it's the ultimate sole decision. And they challenged that in court. It was my opinion and council's opinion in Roanoke that the school board would prevail on that motion, even though you had a contract. And one of the things about a contract, it's okay until it's challenged. And if it's challenged, is it enforceable? And that's when you get into the issue of enforceability. Was that agreement enforceable if it went in front of the court? Well, it got in front of the court was going to have to rule, is it enforceable? And it was my analysis, legal analysis, and still my legal analysis, that the judge, any judge who looked at that, would rule it something called ultra vires, which means that if you're given a legal authority, you can't, and by code and by statute, you can't bargain it away. You can't give that right up. That's your right. Statute gives you that right. You can't give it to anybody else. You can't negotiate it away. You can't enter into a contract to give that away. And there's ample court cases to deal with that. Now, that's dealing with governmental entities. Now, I know there's private contracts, and this is not a private contract in the sense there's three governmental agencies who went together to do this, and that wasn't the public, it wasn't a private company, a private individual, it's three entities. And so, and I deeply respect, I say this all sincerity to Mr. Chairman. Mr. Chairman has a right, he has been very vociferous, very plain, and very emotional, and very emphatic about his love of his community. I don't think anybody, especially me on this, would in any way criticize him for his love of his community and want to defend his community. You have every right to do that, and I admire you for doing that, to stick up for your community. But these unfortunate things that's happened and along the way to us to get here is what's caused us to be here today. And so I hope I've explained that issue to you as to why it is my opinion that it's unenforceable. That contract is unenforceable, even though you got an agreement. The school board did not have a right to give that agreement, to give that statutory right and obligation away in a contract. I know sometimes it's hard to put the legalese into plain language, but the school board legally did not have a right to bargain that in a contract, and that's what the court would have ruled, Mr. Chairman.
One other thing I thought of, and I'm heartbroken on this, Larry, I am. I don't like this, but the thing is, when I look at it, during that time, gentleman's agreement, even though it said and appeared like a contract, gentleman's agreement is what it really comes down to. And the school didn't give anything up. I mean, we gave them control of the money by putting it into their account to where we were being held at bay for the debt. So one of the changes that you guys asked about is the fact that there will be controls. We're gonna get the money to pay that debt and put it aside. That was our, not a win like we would like to see, but it's what we could get. And I don't like it. I think it's gonna hurt our community as well, but it's the bottom line.
I just want to state that from the very beginning, when I've been in office 8 months, when I was campaigning, I made it very clear that I thought the Code of Virginia, there have been some innuendos made about deals and all that stuff. It's absolutely ridiculous. I stated it from the very beginning what my position was, and I think most of us three that were running stated the position that we did realize that the Code of Virginia gave the school board the right to determine the location of the school. Do I like it? You say, well, you're representing the Clintwood district. But if I was not on the board at that time, but $86 million approximately was spent up at Ridgeview, do I think it's a beautiful campus and complex? Yes, I do. Do I think that perhaps they got carried away and spent too money? Yes, I do. I think too much money was spent up there in order that it left Sand Lick. They got the money because my feeling was they got the money. I saw Sand Lick after it was flooded. So I'm very sorry. And I have made no deals whatsoever. I'm pretty sure nobody on this board has. I have nothing against Sand Lick. I love the people of Sand Lick. I want to see them prosper as much as anybody in the Clintwood district. But the law's the law, and I made it clear from the very beginning, the Code of Virginia said the school board had the right to choose the location. How some of these things happened, I was not privy to what happened to the previous Board of Supervisors. I don't even understand how the $6.9 million got put in the school board's name. But that's here and there. Like I've said during my campaign, the horse is out of the barn. We're trying to get the horse back in the barn. It's not the best world, and I too think that it will hurt the community, and I would be much better satisfied today if we had 3 schools at each of the communities. Yes, I would.
And I think most people feel that way.
Mr. Chairman, may I
But there's
speak?
nothing we can do about it right now, Shane.
No, there's not.
The horse is out of the barn.
Mr. Chairman, may I speak? I've been silent. I was the only member of either board that argued that this facilities agreement superseded the Code of Virginia because I'd read the Code of Virginia. And I brought that to their attention, that I did not think it was legal. I voted for it after everybody else voted for it, but I did mention, and I was told, we'll go to court and see if it's legal or not. Now, that's how I was told. Also, I was the only board member that wanted Sand Lick School built from the very beginning. I wanted it first because that was the school that had flooded That and Irvington was the only two schools in the county that ever flooded. I argued, let's do Sand first. I talked to Mr. Moore, I talked to Ms. Robinson, I talked to the school board, but somehow, and David has explained it to me, the rural development money was borrowed only for Ridgeview High School. And we did not overspend. That, that money was set aside, 24 million, to build an elementary school from the very beginning. We did not overspend. We spent what was allowed at those two schools.
Ms.
Correct.
Willis is absolutely correct on that. We can't let that stand, that money that was spent at Ridgeview could have been spent somewhere else, because
No,
that
it was
is
set
not the
aside.
case. Is that right,
No,
David?
the budgets were established with CORE in 2011 or 12, and they did not change.
There was
budget
24
of the
million set
elementary
aside
school
for that
was
school.
always $24.5 million, always.
Sorry for my,
You may be right, that there were
And to
expenditures
answer-
that weren't, shouldn't
well,
have been
it
made.
just seems like, when I first started the campaign, I went to ask how much was spent at Ridgeview. I was given of $86 million. I think we're getting off
We
task
are.
here,
Yeah.
but,
One question
80
I've got, if the FDA is unenforceable, why do we need a resolution to terminate it?
Because it's in litigation.
Just to do away, I meant, to make it look good on paper, do away.
You
with
all are
it.
in
No, because
litigation
it's-
also.
I know. that's what I'm saying.
Well, just to follow up to your question, what would you like to see the school board give up? You said,
I'm
what did
just
they give
curious
up?
if they were giving up anything.
Well, like what,
They're the
though?
ones that sued us, and it's pretty well they're getting what they wanted. And
But
we're
what would you like to
down
see
with
them
that.
give up, though?
Well, I don't know, nothing in particular, I'm just wondering.
Location of the
what
school.
they want.
Location.
That's gonna,
That's the, I was wondering if there was something else I was missing.
hey, it was
Yeah,
clear to
location
me
of
that they
schools.
wanted the 6.9. They want that money.
Yeah.
That's what, they're giving that up.
That's hard, that's not the hot topic to talk about, that's not the sexy issue. The location's what everybody wants to talk about, that's
Yeah,
that's
that-
a point.
so,
There's
but that-
6.9 million that this county is owed, that owes.
The other
School
thing
board
that,
has
what,
held,
the-
that's tied it up.
And
The
never
other
put it
thing
on
that-
interest to make
Listen.
any money
I
whatsoever.
agree, I know that's been going on for.
Yeah.
But the same agreement that
These people
allowed
were elected back to
parties
office,
discuss
too.
where to build the school was the same agreement. That's why the $6.9 million is where it is.
That's
The
correct.
Those issues are all the same.
and that's what I
absolutely right.
tried to clarify in my last comments. They didn't give up anything when that agreement was signed. Because they held to everything. This time, we're gonna be able to control their overspending, and they have to refund what we advance each time, correct?
That's correct.
So
Exactly.
that that's the controls that should have been in place that first time. But everyone thought they were happy-go-lucky. Everyone was working as a team, and it didn't work out
It's a
that way.
love
When I
feast
came
for
in
the
office,
band.
it wasn't that way.
And that's a point that I appreciate Mr. Phillips has made since March, is that he emphasized, and I think we all agreed, that we need to get back to what the law says. And the law is very clear on who does the budget and who builds the school and does the school things, and that's just what the law is. And we have lost control with the FDA on who appropriates money, who borrows money, who spends money, and who does other things. And our number one objective and the oath that we took is to handle the taxpayers' dollars as responsibly as we can. And it's not responsible to spend $250,000 suing each other. And so that's my position, and that's where I'm at, and that's it.
Ms. Senator,
Yeah.
Mr.
I'm
Chairman.
sorry to belabor this, but I'm trying to look out to the future a little bit. When Mr. Phillips mentioned change orders a few minutes ago, I understand the Board of Supervisors will be reviewing those. And I can anticipate, and I guess basically what I want to encourage the Board of Supervisors and the school board is to work out a system so that we don't get hung up on those change orders, because that could be another one of these bones of contention where the school board wants to spend something and the Board of Supervisors doesn't want them to, and so we could get right back into. So we need to work out some kind of a reasonable system where there's maybe a committee. I'm sorry, I can't offer you a solution, but I do perceive that as a problem, and I would like to avoid that if at all possible.
We do have in the agreement a provision to attempt to handle that.
Uh-huh.
And what it says, Ms. Senator, is that any change orders, any proposals in anything that occurs on the TPEA agreement
Right.
that they have to build that school, is that the Board of Supervisors will not reasonably withhold any funds or changes as long as it comes within the confines of the budget.
Right.
Now, if it goes over the budget, that's going to be another
that-
question.
Stay within
But
the
you know, the devil's always in the
Yes,
details, and that's
that's
my
correct.
concern.
And I agree, and that's a good point, and it's always easy to say, but I don't foresee us wanting to get into the details of,
No, they stay
how
within-
big the gym shower is,
Yeah,
or
we are
whatever.
not
I mean,
interested
you know,
in that.
we
What
don't-
color the tiles are. or
Exactly.
some such. Okay. Well, my motion remains on the floor, Mr. Chairman.
Was you want to say something else, Mr. Phillips?
Mr. Chairman, I just to finish up, I know that the folks from Hayside, they're good, and I'm just personal, a point of personal view, Mr. Chairman, I'm not going to speak as a lawyer right now, but I want to speak as a citizen and community of this community, this county. I know the town of Hayside, the Hayside community, all are very passionate about their community. I know they feel like that maybe if things had changed, that they would have gotten a school close by down there, and that maybe have been the case. But things changed, and those things were detrimental to, in a sense, and I'll say very plainly, to the community of Hayside getting to school, what those things happened. You know, you got the school board, they make decisions, we have to make decisions about where we go in terms of policy. And, you know, I feel for the people in Hayside. I empathize with the people in Hayside and your community down there and your citizens. And so it's not a matter, and there's people on this board who also feel the same way as I do. They empathize with your community and emphasize and have great empathy for your community and your children. And and so unfortunately, sometimes, and I said this in one of the meetings, and maybe I didn't say it as artfully as I should, you know, I'm trained to think with my head when I get in legal issues, and I have to put my issue about my heart. My heart may be in another place, Mr. Chairman, on this issue, but the legal, I have to go where I have to go.
Thank you for that.
Mr. Compton, did you have something that you started to say a minute ago?
Just, the only thing I would say, we need to get this over with. It's just drug on and drug on and drug on.
And go forward
Got
together.
other
Go
things to
forward
fix.
together, and, you know, I hear in the community all the time about how much money this county's wasting. And for years, this has been going on. Our board has had a resolution to support the school at Hayside. That didn't make any difference. All the resolutions we done, we sat over here in meetings and had a judge come in and talk to us and all that. We all agreed to go to Hayside. It doesn't do any good. We need to get this over with and move forward for the best of the county. And hopefully something good will come out of it. The community will come together, hopefully.
You're talking about the judge in the mitigation that we sat through 12 hours
The
that
mediation.
day.
Yeah,
And we got nowhere.
no, we got a sore hind end, got a little meal out of it. That don't-
And I mean, I told him I liked the Clinchco site, my personal, I liked it. He said, that's the worst site I looked at. And that was the site he chose,
And I didn't
What was
mean,
that at, Ms. Wilson?
the mitigation. You know, he
Mediation.
chose Clinchco. But
Oh, okay,
when
yeah.
I asked him, I said, I like the Clinchco site myself. He said, oh, no, that was the worst site I saw.
and Mr. Yates, I didn't mean to take over to ask him to speak, but I seen him sort of raise his hand there a minute ago, and I
Well,
thought that he
we're all
was,
Family and friends in here, you know.
Okay.
You don't apologize to me. Okay, let's try to get, move on to the procedural matters. I think we have a motion on the floor from Ms. Center.
That's correct.
Mr. Chairman, I'll offer a second on that.
Okay, we have a motion and a second on the floor. Is there any further discussion? Hearing none, we'll do a roll call vote. Ms. Center?
Once again, I want to reiterate Mr. Compton's comments, and I'd like for us to go forward, move forward together and try to do something for our children. And I vote in favor, Mr. Chairman.
Is that a yes vote? You
Yes, I
yes?
vote in favor. Yes,
Favor,
sir.
yes, okay.
That's a yes vote. Phil?
No, I'm a no vote.
Mr. Compton?
Yes.
Okay, Guess it's my turn then, just going by where we're traveling here. You know, I still believe legally that we have a good standing. I believe everything that was put in place whenever we started down this road was put in place for the very reason we're here today. I think the Facilities Development Agreement should still stand. I understand all the reasons that's been explained to me here, the reason why it shouldn't this afternoon. You know, when you have to hide behind the law, it doesn't make it that much, it doesn't make it all that much good, I don't think. And I feel like that's what the school board's doing, is hiding behind the law by exercising their right to choose the location, because they signed that right away when they signed that Facilities Development Agreement. So in many ways, I still think our students are being second bested. I think we're taking second back seat by building the school anywhere but in Hayside, Stanley, or Clinchco. And I would be satisfied with any location. And I speak that not only as a member of the Hayside community, but as a Dixon County citizen. I feel that very strongly as a county citizen, that this is the wrong thing for our county. So please record my vote as no. Matthew?
I feel very strongly, you know, just as you do, Mr. Chairman, just as I stated before, the Hayside community lose a school, lose that opportunity. But I also do believe that it's time to move forward, and it's time for us to end the litigation, and I'll vote yes.
Mr. Stanley, can you hear us okay?
Yes, yes.
How do you vote, sir?
I vote yes.
Thank you. John, that comes down to you, Mr. Johnson.
I'd like to take the time to say, of course, I'm probably the newest member on the board, and I appreciate the opportunity to serve. And I 100% totally understand all this debate as far as mixed emotions and feelings and that kind of thing. However, just from what I've heard and what I understand, this comes down to a decision of just moving on and trying to make a decision and not fighting anymore. And I just have to say that as far as myself, I agreed to serve on the board of on the Industrial Development Board because I want to try to help see an increase in business and industry and that kind of thing for our community. And we have elected officials on our school board and elected officials on our Board of Supervisors. And, you know, everybody, every district has a representative, and, you know, those choices just have to be made by those elected officials. I was never involved, wasn't here when these agreements were being made, but I just feel like that if this is holding our county back and we're fighting and we're in litigation, that if two boards have accepted the resolution, that it's just time to move on and move forward. So my vote is yes.
Thank you, John. Thank everybody else. We have a,
Mr. Chairman, you may want to announce the vote.
yes, sir, it's five yes, 2 no. So that motion carries. Okay. Is there any other discussion about the division of money? None? Any other member comments tonight from the Dixon County Industrial Development Authority Board? Hearing none, Mr. Evans, I'm going to let you take back over the meeting if you want to.
Well, thank you, Mr. Yates, and I appreciate your board and Mitzi agreeing to call this special meeting tonight, and I appreciate the comments made by you and all your members from each perspective on that issue. I don't have anything left I want to say about it. Like I said, I feel like I've been in a boxing ring with Mike Tyson for literally 8 months. But I want to move the county forward, and that's what we're trying to do, and that's what we've done now with all 3 boards approving the resolution. So I'm going to move on.
Mr. Chairman, I'd like to say that I would like to see us have a school where all of our kids could go to one school. I've always wanted, I hate to leave my kids down at Clintwood when they would be a nice new school up on Ridgeview. But that may not be, but that's their decision to consolidate also. It's not ours. But I appreciate the vote that everybody's had. I want to move forward also.
Yes, ma'am. David, I see item 2 on our agenda, the Trammell revitalization project, but I don't see a model resolution in my packet anyway. Is there one, or is that
They
a,
may have one to hand out or something.
I don't think I've seen it.
It may not got in your package, but there is one, Mr. Chairman.
Chairman, could we
No, I
not
didn't
adjourn and
get
go
it,
home?
okay.
You may.
Mr. Chairman, do you want them to go ahead and close their?
Yeah, if you, Mr. Gates, if you don't want to stay around, if you want to go
Do
ahead
you need
and,
us for anything?
not that I'm aware of.
No, this won't take you 2 minutes.
Okay.
Yes, please.
Move-
I would
Mr.
like you all to
Chairman,
know
I
I'm
move
the only
we
district that doesn't have a school.
Okay, we have, excuse me, we have a motion and a second for the Industrial Development Authority to adjourn. Any further discussion? Hearing none, all in favor of adjournment? Aye. Anyone opposed? Industrial Development Authority is adjourned.
Thank you all.
Thank you all.
Thank you.
Thank you, Mr. Stanley. You may go now. He's going to disconnect you. Thank you.
I don't have that in my packet about Trammell.
I'm the only school in the, I'm the
Well,
only
you did
district
till they
in the county that
tore
doesn't.
down Longsboro.
Well, and Irvington High School's my district.
Yeah.
All right, has everybody seen this resolution? I've read it now. Is there any questions or discussion?
I haven't seen it, but I think I about know what it's about.
I don't know what it, I don't have it.
Greater flexibility so that we don't have to wait.
Did we get a copy of it?
Things done.
I didn't get a copy.
I was
Did they get in?
Yeah, he tried to
building inspector, Rex, and also Attorney Phillips on any issue that comes up.
You want to see it?
Ms.
Get
Isaac,
a hold of
your initial your project will consult you, this just keeps rolling.
Yeah.
Mr.
And
Phillips,
I will make a motion that we accept this resolution.
anything, Mr. Phillips, on this resolution we need?
No, it just says the county administrator indicated it expedites the contracts.
Yes, sir. So we have a motion to approve the resolution. Do I hear a second?
I'll second it.
All those in favor, please signify by saying aye. Aye. Aye also. Is there any further comments anyone would like to make? If not, I'll entertain a motion to adjourn this special call meeting.
I make a motion to adjourn this special call meeting.
All those in favor of adjourning, please signify by saying aye. Aye.